participating in this oral argument, which is being live streamed as we speak. A recording of it will be posted on the Administrative Office of the Court's website at a later date for future reference. We will conduct the argument today in the same fashion as if all of us were in the courtroom together. Both sides get 15 minutes, and of course, the appellant may reserve up to 5 of that for your rebuttal, which I understand you've already done. Unless there are any announcements, we will ask Mr. Hibner to call the case.
Abbie Joseph Howell versus Lauren Elizabeth Howell.
Mr. Ladner.
Thank you, Your Honor, and may it please the court. I never thought I would make an argument before this court sitting down. I certainly never thought I'd make an argument before this court having gone 4 months without a haircut. So I apologize for both of those. I am, however, wearing pants. I hope I get credit for that.
Well, I just hope you get your office back someday since you're now having to work from the street. So.
It's okay. It's 78 degrees today.
Oh, that's true.
And yes, Your Honor, just for the record, we would ask to reserve 3 minutes at the end of the rebuttal.
Certainly.
Now, Your Honors, the issue here is a prenuptial agreement that was entered into by the husband and the wife in this case. Now, there are a number of issues with it that we raised at the trial court that we believe are properly preserved for this court. As Your Honors are aware, the standard in this state is that prenuptial or antenuptial agreements are favored. However, they are not automatically rubber stamped as valid. That is the quote from this court. In order to prove that it's valid, it must be freely, knowledgeably, and entered into in good faith by both parties. And the burden is on the party seeking to enforce the agreement to prove all those factors. The most recent cases that have dealt with these issues are Ellis versus Ellis and Randolph versus Randolph, which we've cited in our brief. And they delved into the meaning of the word sophistication. Specifically, it relates to sophistication of the parties relative to each other, not just relative to the world at large, and certainly not relevant to their legal sophistication. In this particular case, the wife was 19 when the parties met. She moved in with Mr. Howell the next year, and they lived together for 6 years before being married. At the time they were married, Ms. Howell was 26, and Mr. Howell had been practicing as a pharmacist with a graduate degree for longer than Mrs. Howell had even been alive. He'd been married, I believe he was widowed. He had children. He'd had multiple jobs as a pharmacist. Mrs. Howell, however, had nothing more than a high school degree and a couple of prerequisite community college credits to her name at the time they entered into the marriage. At the time they entered into the marriage, she was substitute teaching for around $50 a day, which is what the testimony showed. And she worked occasionally as a cashier at one of the pharmacies, I believe, that her husband had worked at. Now, legally speaking, they may have similar levels of sophistication because neither of them are attorneys. However, that issue has been addressed by this court before, specifically in Randolph versus Randolph, where the husband was significantly older than the wife, had been more experienced in business dealings and his job. The wife was much younger and had essentially relied on the husband for the majority of her adult life, which is exactly what we have here. Now, the factors that are relevant to whether the sophistication of the parties shows that they could enter into it freely and knowledgeably and in good faith. There are a number of factors that this court has addressed before. One of them is the time between when it is signed and when the marriage occurs. In this case, there were only 11 days between when it was signed and when the marriage occurred. This court has invalidated prenuptial agreements that were that had more time than that. I believe there have been some that have been validated where the time was shorter. One of the other factors is illness. In one of these cases, the woman literally had to get out of the hospital so they could be married. She was hospitalized the day after they signed the prenuptial agreement. In this case, the record shows that Mrs. Howell was suffering from acute pancreatitis at the time she signed this agreement. In fact, she signed this agreement about a half an hour after she threw up while the parties were at lunch. The ability to have an attorney and whether or not you can afford an attorney, whether or not an attorney is actually truly furnished or just mentioned in name is another factor that's been introduced as to whether or not an agreement should be validated or not. In one of these cases, the husband offered to pay for an attorney and insisted that the wife get one, and the wife declined because she trusted him. And that was later invalidated, and the court said essentially that he should have just went ahead and got an attorney for her. In this case, the record shows, and Mr. Howell himself testified that he did not get an attorney for her. He didn't offer to get an attorney for her. In fact, I believe his exact words were that that's her responsibility. He never even mentioned to her that she could get an attorney, nor did his attorney who drafted the agreement mention to her that she could get an attorney. Additionally, on the prenuptial agreement itself, it looks, I believe most of them testified that it was copied and pasted and drafted within about a half an hour. The husband took the wife to his attorney's office, told them to draft the prenuptial agreement. They went to lunch. The wife threw up because she was sick. They came back, and the agreement was ready, and it was signed right there. It was gone over and signed while the paper was still hot. At no point is there any proof that Mrs. Howell was ever told she even had the ability to get an attorney. And they've admitted that no one offered to pay for it or no one suggested that she should get an attorney. It's also important to remember that in the agreement itself, it says that both parties had independent counsel that had looked at the agreement. Well, as the testimony in court showed, that wasn't true. I believe that it was that was a copy and paste error from the attorney who drafted that agreement. Now, Mrs. Young has not argued the doctrine of severability. I don't know that that would apply here. We haven't raised it, but it does go to show that this was very hastily put together, slapped together, and essentially put in front of her, and she was told she had to sign this, otherwise the marriage wasn't going to go forward. The testimony from the parties is that if she wanted to get married, she'd have to have a prenuptial agreement. However, no agreement was ever drafted prior to this. No specifics were ever mentioned prior to this in such a way that she had time to investigate it. At no point during their 6-year relationship was it ever suggested that this would be a prenuptial agreement that might need to be signed and that she might want to get an attorney to look over it. That was never offered. She was hospitalized, I believe the testimony was for about a week or so, and got out of the hospital, and the marriage occurred, I think 3 days, give or take, after she got out of the hospital after having, I believe she had a pancreas removed or had some major surgery done on it. Now, these factors for invalidating prenuptial agreement, the length of time between when it was signed and when the marriage occurred, the knowledge of the parties of business and of the world relative to each other, the relative sophistication of the parties, whether one party is suffering from any kind of illness that might prevent them from being able to fully understand and appreciate and execute these documents, whether or not an attorney is offered, whether or not an attorney is suggested, whether or not an attorney is paid for or offered to be paid for, whether or not someone was told if this isn't signed, then we can't get married. All of those are factors that have been found on their own to invalidate prenuptial agreements by this court before. In this case, however, we have each one of those factors, and we have them in spades. Now, it's undisputed that the wife did not understand the prenuptial agreement. And Mr. Howell's argument in the transcript is that if she didn't understand it, that's her fault. She should have spontaneously realized that she could get an attorney and try to go get one. But both parties testified she didn't manage the money, he managed their money. Even if she wanted an attorney, even if she knew she couldn't get one, she would not have been able to afford it. That is not in line with prior decisions on this issue. As I said, there have been cases in which husbands have even offered to pay for the attorneys, and this court said that that wasn't enough. This woman is 25, 30 years younger, and she doesn't understand what that is. You need to basically get an attorney so that someone else can explain it to her. You can't trust her to rely on you for that if you expect the agreement to eventually be validated. And I would submit that's exactly what we have here. Are there any questions from your honors?
Hearing none. All right. Thank you, Mr. Ladner. We'll hear from Ms. Young.
Good afternoon, Your Honors. Laurie Young from the Rutherford County Bar. Basically, I'm going to start and discuss them in the same order that Mr. Ladner had. The sophistication is interesting. In according to the record, Miss Howell graduated with honors from high school. Her ACT score was higher than my client's. The sophistication does not come from being a pharmacist at Fred's Discount Pharmacy. I'm not being offensive to Mr. Howell, but they live in Woodbury, Tennessee, and they really had no assets. When they're talking about sophistication in these cases, what they're referring to in Ellis versus Ellis is he had millions of dollars. My client had his asset list includes about $100,000 equity in a house. That's all they have. And so when they talk about sophistication, in that case, she was pregnant. It was 3 days prior to the marriage. This is Ellis versus Ellis. And it was December the 23rd. Yes, he offered to pay for her counsel, but it was December 23rd. She said she called around, couldn't find one. He didn't disclose his assets as a reason they set that aside. He had a multi-million-dollar construction business. My client disclosed all of his assets. That's never even been raised in any of this appeal or at trial that they weren't disclosed. They're clearly disclosed. It's attached to our prenuptial agreement. She might have been younger than my client, but she was in college for a pre-pharmacy degree, which means she had to be fairly intelligent to pull that off. And so I wouldn't think sophistication is what these case law is referring to in regards to a pharmacist and a college student. We were all college students at one point. We all had a job making back then $3.23 an hour, but now $10 an hour. That doesn't mean she wasn't smart and she couldn't read and she didn't understand. It just meant she was in that phase of her life where you go to college and you work a minimum wage job. My guy, doesn't have investments. He wasn't in the stock market. He's not running some business. He literally is a W-2 employee at Fred's Discount Pharmacy in a rural county in Tennessee. She was not financially dependent on my client. She had a job. And in addition to that, she was getting $1,400 a month inheritance money. It didn't really say in the transcript. I think it was a trust. It was from someone. But she had that in addition to her $10 an hour job and no bills. She clearly did not need help hiring a lawyer if that's what she wanted. As far as her sickness, my client, that's disputed in the transcript. He said she didn't throw up during lunch, didn't know she was sick. This pancreatitis had to do with her blood sugar issues, is what my client says in the transcript. And she'd had the same issue 2 times prior to that. Apparently, it's a pretty easy fix. You get checked in the hospital, they level out your blood sugar, and then she comes right back out. And so that was not a new issue in their relationship. That was something that had happened.
Surgery? Was there a surgery?
No surgery, Your Honor.
Was she in the hospital for a week?
I think 5 days.
Okay.
I'm not positive on that, but it was a short period of time, and it was to regulate her blood sugar. And she wasn't sick. It happens really quick. She apparently is diabetic and it comes on really quick. My client says she never said she was sick, that she wanted to go home or that she puked. I would assume the person you're eating with, you would say, hey, I just got sick in the bathroom. Nothing like that. And so they lived together 6 years prior to this marriage. He never threatened or suggested her moving out if she didn't sign. My client didn't even want to get married. He is a widow or was a widow, and she's the one that wanted to get married. His testimony says he was happy with the status quo and it didn't matter to him. And so she's the one that wanted to get married, and the prenuptial agreement had been talked about for years. That's also in the transcript. Even my client's sister testified that it had been discussed and that he wasn't getting married without one. So it wasn't some surprise on 11 days before the marriage, hey, by the way, I want you to sign a prenuptial agreement. It had always been talked about and knew that it was going to happen. And so I would say these cases that he cited, the Randolph case, I've talked a little bit about Ellis. It was 1 day prior to the marriage. There was non-disclosure, and the only choice was to sign the agreement or be kicked out of the residence. And so your honors set that aside. Mr. Howell was not threatening that, never told her that, wasn't going to kick her out, was fine. He was paying her bills, but she also had money. So she knew about his assets. He was building the house when they began dating. They dated for 6 years before they got married. And she was fully aware that he used his wife's inheritance money from her life insurance to put the down payment on the house and to build it. And if Your Honor will look in the transcript and the pictures that were submitted, and again, I don't mean to be disrespectful to the Howell family, but look and see if you think that house is, I mean, the pictures are appalling that were taken that I submitted to the court about how she kept this house. That's what we're fighting over. And it was, my client had it before and used inheritance money. They had a joint.
Let me ask, Ms. Young, you say she knew about his assets. The listing of husband's separate property is pretty modest, other than the only specific is that he had $571 in a bank account. That's the only financial number I see. It does identify real estate, but how does that comply with the full disclosure concept?
Well, the fact that she was there when he built the house, when he got the loan, she was fully aware of all of that. She is on a joint bank account with him where the mortgage is paid out of.
Well, but are there any other assets that she didn't know about or that she did not appreciate?
No, sir. These are their only assets, 2 timeshares. And these really are the, one of these properties got sold. There's really only one of those. One of them was sold during the marriage.
Okay. All right. Thank you.
You're welcome. So basically, she had been that same sick. He didn't care if they got married or not. And the Grubb case was 2 days before the wedding. And it was on December the 23rd. And so she was financially dependent on him. These cases that Mr. Ladner has cited, all the wives were financially dependent. Here she wasn't. She had her own job. She had $1,400 a month coming in. And so she wasn't pregnant. She just wanted to get married. And so that was okay with him, but he wanted the prenuptial agreement signed. He didn't need to offer to pay for her lawyer. And everything had been disclosed. It's again, like you said, a very modest estate. And I'm not sure what she's fussing about. My client makes $70,000 to $80,000 a year. He has no assets apart from this house. And she doesn't have any assets either apart from a car. And so I would say to Your Honors that there was a full disclosure, that their sophistication is not far apart. It just, they're different stages of life based on their age and where they are. Doesn't mean that he knows more than she does or that he's going to hide. And most of these cases that were cited, they didn't have disclosure. One of them said 97% non-disclosure. And so that's clearly not the case here. She's on the only bank account he had. So,
and what does the prenup say about alimony?
She doesn't get any alimony
under the prenup. So
yes,
she fully understood what that means, is what your position is, that she wasn't going to get any support.
Yes. And she hadn't been receiving any support. My client wasn't giving her money. He was letting her live there, but she had her own money at the same time and hoping that she was going to get through college. I mean, I don't know if she's graduated at this point or not, but at the time of the trial, she was going part-time still and working at a pharmacy.
I mean, I guess my point is I can understand if there's not a lot of personality or realty that she might have a full comprehension of what that meant, but I just have some problem feeling like she fully comprehended that she was giving up any right to spousal support instead of an ultimate divorce here.
Well, it's pretty clear here in the prenuptial agreement. It says the parties agree that neither party should be obligated to pay the other alimony, spousal support, or any other type of separate maintenance in the event of legal separation or divorce. That's paragraph 9, page 4 of 8. I mean, it reads pretty clear.
The attorney who drew it up went over it with them, right?
Yes, that's what my client said.
Did he go section by section and
each
explain
paragraph? Yes, sir. That's what it says in the transcript. And then they initialed at the bottom of each page. And she didn't ask any questions. I don't think she clearly wasn't surprised because they've been talking about it all these years. So that would be my argument, Your Honors.
All right. Thank you, Ms. Young. And Mr. Ledner, you have some time for rebuttal.
Thank you, Your Honors. A couple of issues I'll try to get to quickly here. Sophistication is not the same as intelligence. That is correct. There's nothing to suggest that either of these parties are unintelligent. However, I would say that the husband is coming into this argument with unclean hands to claim that she made her own money, she could do what she wanted. I'm pretty sure from the record on this, she has a trust from her father's estate after he passed away that gave a payment once a year. She didn't have a $1,400 a month salary or check that just came in that she was using of her own volition. And that money that she did take in was managed by the husband. In fact, as Ms. Young just stated, the husband was the one that controlled what happened with that money and used, on 1 year, he used the payout from that trust as the down payment on the house that they were living in together. This house was purchased while they were together using some of the money from her own trust from her father's estate that they lived in together for 6 years before they got married. And for, I believe it's been 7 years since they've been married, maybe a little bit longer at this point. They said that she was making her own money. She was working, but as the record shows, she was making $50 a day, 2 or 3 days a week, substitute teaching. Now, yes, she was going through community college classes, but even at 26 years old, she had yet to even get an associate's degree.
Mr. Ledner, the statement of separate property says the husband's individual checking account was at Regions Bank, but that the wife's individual checking account was at First Bank. Are you saying that she didn't maintain her money in her own separate account?
That is correct. And I believe the testimony was that when her money came in, she would ask him what to do with it and he would tell her where it was going to go. There were some times where she used it for something else, but there was testimony that he told her 1 year to use that money to help fix up a pole barn that they had. There was another year where he had her put that money toward the down payment on the house that they lived in together. And this argument that he's this country bumpkin that doesn't know any better. Again, he was a pharmacist before she was even born. And he testified that he came to work every day wearing a nice shirt and a tie, dressing well. But he came into court, and it's in the record, came into court wearing jeans and a flannel shirt, trying to act like a country bumpkin who didn't know any better and wasn't trying to pull one over on her with this. Well, Your Honors, there's just no practical time when she's in the hospital for 5 days to be able to get an attorney. The judge in this case said that she could have called an attorney from the hospital bed while she was suffering from pancreatitis. I don't know if any of you have had it. My father's had pancreatitis. It's not the kind of thing where you're sitting there doing business deals. Additionally, the language in this prenuptial agreement might be fine for attorneys. We can all read that one sentence and understand it. It might even be fine for someone who's been divorced before, as Mr. Howell had. But for a 26-year-old who's been with the same man since she was 19 and trusts him on everything, I don't think that's nearly sufficient to show that she understood what she was signing.
All right. Thank you, Mr. Ladner and Ms. Young, for your arguments. We will take this case under advisement. Mr. Hibner?
This honorable court is now adjourned.